Hearing the appeal of John Mussington and 11 against the Development Control Authority and 2 others.
Good morning, Mr. Weathers.
Good morning, my Lord. May it please my Lords, I appear on behalf of the appellants, and I appear together with my learned friends. To my left, Professor Leslie Thomas, KC. Behind me, Stephen Cottle, Talia Mirage, and Adam Riley. Can I introduce my learned friends for the respondents? The first and third respondents are represented by Dr. David Dorset, Carla Brooks-Harris, and Roseanne Kim. And the second respondent, the Airport Authority, is represented by Mr. Hugh Marshall and Keema Benjamin.
Thank you.
My Lord, the appellants, John Mussington and Jacqueline Frank, sit behind me in the second row, immediately behind me. They're here to listen to their appeal, and as your lordships will have read, they are Barbudans. They live on the island in Codrington, not far from the site about which this appeal, which is the subject of this appeal. The first appellant is the principal of Codrington Secondary School and a marine biologist. The second appellant is a retired school teacher. Can I deal with some housekeeping, my Lord? Your lordships have an electronic bundle. There was some additional evidence put in by the appellants by email, an email sent to the registrar of the court, and you'll find that at page 3551 to 3634. That material was not before the East Caribbean Court of Appeal when it gave judgment on the 29th of April 2021. And your lordships would have seen, I think, a position statement put in by the first and third respondents at page 3786 to 3787, which in effect, I hope I'm summarising it accurately, indicates that although they do not formally oppose the admission of the evidence, it's a matter for your lordships, obviously, as to whether or not it should be taken into account. I'll say no more about that at this stage. The email itself, sent in by my instructing solicitor, Mr. Solly, makes reference to the material and then the reasons why it wasn't available at the time when the Court of Appeal determined the appellant's appeal on the refusal to grant an interim injunction, and the reasons why we say it should now be admitted and considered by your lordship.
I'm sorry, Mr. Weathers, what was the page bundle
of the
page reference for the additional evidence? I thought you said 3.
My Lord, yes, it's page 3551, sorry, to 3634. The letter itself, the email, I should say, is at 3549. And that was an email sent to the registrar on the 29th of September 2023 by Mr. Solly. And then the first and third respondents' position statement, dated the 10th of October 2023, is at 3786. And the documents included hydrological, geological and ground-penetrating radar reports, which had not previously been disclosed, a review of the 2018 revised EIA by the Department of Environment dated the 4th of October 2018, and a letter sent by Mr. Smith of the second respondent to Mr. Southwell of the first respondent, dated the 18th of September 2018.
Thank you.
Thank you, my Lord. There was also submitted by the appellants a document headed reply, and it was a reply, submissions in reply. These were submissions which have been prepared to give both the board and the lordships and the respondents advance notice of certain points that the appellants would wish to raise in reply to the respondents' arguments on the question of whether or not the appeal is academic.
Yes. Is that something you can leave to your reply submissions?
It would certainly assist me, given the amount of time I have in which to make submissions on the key element of this case, which is, I would submit, the question of standing.
Yes.
It encapsulates much, if not all, of what I would wish to say about the question of whether or not this appeal is academic and whether or not your lordship should consider it.
I think this is an appropriate point for the board to indicate that it wishes to hear the respondents on the merits of the case. This is a case which has been given permission because it raises a point of general public importance, and while we will hear the arguments on the appeal being academic, we also wish to know the respondents' position on the merits of the case.
I'm very grateful, my lords. What I was going to say, but perhaps it's already been said by your lordships, is that the point hadn't been raised at the local court level. We are here now, permission having been granted, and that in those circumstances, whether or not the case is academic, it is a matter that ought to be considered by the board. So the summary of our case, perhaps if I can set that out, in essence is this, that as you'll have read, my lords, Barbuda was hit by a devastating hurricane 6 years ago now, in September of 2017. The population, the Barbudan Islanders, were evacuated and a 1-month state of emergency was declared. They returned to discover that construction work had begun, first at one site, which was eventually abandoned, and then at the site that we now know is the subject of this appeal, where a runway has been constructed. And I ought to say that it is agreed that the runway has been constructed. That was a matter agreed in the statement of agreed facts.
Yes.
What we don't agree, and your lordships no doubt would have picked this up already, is that an airport has been constructed. There's no concession on the part of the appellants that an airport has been constructed, so anything said...
There are no terminal buildings or anything like that, as far as I understand it, simply just
no air traffic control tower, if indeed there was to be one, no fuel depot, none of that nature. I think there are some buildings that are being constructed, but whether they have permission for them to be constructed is another matter. We just simply don't know.
There'll be a number of questions, I suspect, that members of the board will be asking you about the background to this matter. But what was this airport part of the development plan? The Antigua and Barbuda development plan, that I don't know. It certainly wasn't the subject of the planning applications that have been made. There was one application made on the 27th of November 2017 for a runway. Perhaps I could just take you through that. It's helpful to understand the background to this. I mean, what was an airport in this location configured in the development plan? Was there consultation of the Barbudans on that development plan? Was there consultation on or advertisement of the planning application to build the airport? These matters aren't entirely clear from the papers.
No, I know, my lord, and I'm going to take... would you mind if I take your lordships to those points, or perhaps address them as I'm taking your lordship through the...
I'm perfectly happy with that, but these are matters that the board wish to have clarified.
Well, I'm glad that the board is interested in those matters. So forgive me.
So you were saying that the runway was now constructed.
Exactly, my lord. And putting aside the question of what has and hasn't been constructed, the appeal itself concerns a very important but relatively short point, you might think, and that's whether or not the East Caribbean Court of Appeal erred in law when it determined whether the appellants had standing to bring the claim by way of judicial review in relation to the development of the airstrip or runway on the island of Barbuda. There are 4 grounds of appeal. The first ground of appeal really focuses on the question of the interpretation of CPR 56 2.1 of the civil procedure rules and the interpretation of the words sufficient interest, and whether or not the case of Walton, and indeed subsequently considered by the Northern Ireland Court of Appeal in the case of Duff, really sets out the approach that should be taken to the determination of sufficient interest. The second ground of appeal concerns the question of whether or not the Court of Appeal ought to have taken into account the very fact that there had been no disclosure of the environmental impact assessments, and had there been indeed disclosure of those environmental impact assessments, the appellants suggest that they may have been in an even stronger position to make their case on standing. Somewhat speculative, because we just don't have them. But
you haven't received it, but again, is there statutory provision requiring the publication of an EIA?
Well, that I don't see in the Physical Planning Act 2003.
No.
But one can infer that publication ought to take place in circumstances where there is the potential for a challenge to the grant of planning permission where an EIA is required, as was in this case. But it's impossible to perhaps properly challenge the grant of planning permission and the basis on which an EIA has been adopted without seeing the document.
No, but I would have thought the norm internationally is that an EIA is made available so that people can comment on it.
Obviously I appreciate we're used to a different regime, but yes, under the Aarhus Convention, the purpose of having an EIA is to enable the public to participate in the process. Well, that's a major purpose of it.
Well, exactly, my lord, and it's a matter for your lordships how far your lordships take into account the Escazú agreement that was ratified by the government of Antigua and Barbuda.
Yes, it is on the international plane.
It is on the international plane,
but it can be relevant for interpreting
yes,
domestic legislation.
Yes, and we set out in our written case, and I'll just draw your attention, my lords, to the specific paragraphs. For your lordship's note, we set out the relevant provisions from paragraph 72 down to paragraph 78, and your lordships will see that this agreement, regional agreement, was ratified, paragraph 72, this is page 1660 for your lordship's note, ratified on the 4th of March 2020, so during the course of the proceedings, and indeed only a couple of weeks, I think, before one of the particular steps taken by the respondents, that it, in Article 5, paragraph 74, requires each party to ensure the public's right of access to environmental information. Requires that access to environmental information be facilitated for persons or groups in vulnerable situations. And we say in that very same paragraph that the Barbudans we represent could be said to have been in a very vulnerable situation in the aftermath of Hurricane Irma. Article 6 requires that each party shall guarantee to the extent possible within available resources that competent authorities generate, collect, publicise and disseminate environmental information. Crucially, we say Article 7 requires each party to ensure the public's right to participate in environmental decision-making processes and to provide specified information to the public to allow them to participate. And then if your lordships look at paragraph 77, Article 8 is mentioned there. It requires each party to guarantee the right of access to justice in environmental matters Article 8.2 requires each party to ensure in the framework of its domestic legislation access to judicial and administrative mechanisms to challenge the appeal with respect to substance and procedure, any decision, act or omission relating to the access of environmental information, any decision, action or omission relating to public participation in the decision-making process regarding environmental matters, and any other decision, action or omission that affects or could affect the environment adversely or violate laws and regulations relating to the environment. And what we haven't mentioned there is Article 8.3, and if your lordships just perhaps turn up Article 8.3, which is at page 3533 to 3534. Your lordships will see that the SCASU agreement has something particular to say about standing too. It says, excuse me, 3533, to guarantee the right of access to justice in environmental matters, each party shall have, considering its circumstances, and then if one looks at little c, broad, active legal standing in defence of the environment in accordance with domestic legislation. Broad, active legal standing in defence of the environment in accordance with domestic legislation. So the SCASU agreement, which was ratified by the government of Antigua and Barbuda, we would respectfully submit, clearly suggests that there ought to be every opportunity given to the public to participate in environmental decision making, and that they should be given a broad standing in which to do so.
I'm just trying to follow the timeline, though.
Certainly.
It was only ratified on the 4th of March 2020,
Yes.
which is after the promulgation of the CPR and after the relevant legislation. Are you saying that it affects the interpretation
I'm saying
of either of those?
My Lord, I'm suggesting that in the event that your lordships have any concerns about the interpretation of CPR 56.21, and if there's any ambiguity in terms of the term sufficient interest, then your lordships can take account of the SCASU agreement and the provisions I've laid out in terms of that interpretation.
Is there any information?
Sorry, Miller.
Is there any information about the genesis of the obligation to prepare an environmental impact assessment in the legislation? I mean, what lay behind that requirement?
My Lord, in answer to that, the honest answer is I don't have any knowledge. We haven't. I don't think we've actually looked to see what the genesis of the legislation requiring EIA stems from. But we can certainly provide your lordships with a note of the genesis.
So just still on the timing, and I'm sorry to take up time on this. I mean, the judge who had to consider the grant of leave in the first place was considering the matter in 2019 and made her decision on the 7th of February 2020, so before ratification of the SCASU agreement.
That's right, my Lord. I'm
just trying to see what you're saying. Are you saying that the meaning of the CPR changes between the first instance and the second instance decision?
Well, no, I'm not necessarily saying that. What I'm saying is that Mrs. Justice Wilkinson made it plain that she felt that the appellants were entitled to standing because of their participation in the proceedings, and she dealt with it pretty swiftly on that basis. I think paragraph 26 of her judgment. The East Caribbean Court of Appeal considered that she had got that wrong. They didn't see that there was any authority for her decision on the basis of the appellant's participation, and they went further and rejected the submission made by my learned friend to my left, on the basis that Walton was applicable. They discounted Walton on the basis that it was it was not a judicial review case, and they went further and concluded on the basis that on the basis of their interpretation of CPR 56.2, the appellants were not entitled to standing. Now, we're looking at the position again on appeal. I'm indicating to your lordships that the Escaso agreement suggests there ought to be a wide interpretation of any rules relating to standing in the countries which have been ratified.
Was this a point taken in the Court of Appeal?
No, my lord, no, it wasn't.
So this is a new point?
It's a new point, my lord, yes. And it's an interpretation point, my lord. So, my lords, I was running through the grounds of appeal.
Yes, you've given us the second ground.
The second ground. The third ground, perhaps, is one I've already touched on, which is the question of the appellant's participation in the proceedings. We've just been through, as it were, the chronology without looking at the papers, but Mrs. Justice Wilkinson, having concluded that the appellants were entitled to standing, but didn't mention any authority for that conclusion, the East Caribbean Court of Appeal considered that their involvement, and indeed the statutory provision in the Physical Planning Act, which entitled those who made representations to have those representations taken into account, didn't get the appellants home on standing. And the East Caribbean Court of Appeal didn't, we would respectfully submit, appreciate that the very authority for there being standing ordinarily being bestowed on applicants for judicial review who have participated in the planning process was the case of Walton. And indeed, that's set out by Lord Reed in paragraph 86 of the case of Walton. And then ground 4 is all about timing. It's something of a procedural challenge to the Court of Appeal's decision to grapple with the issue of standing after leave had been granted, but before the trial of the substantive claim. And their decision to do so was based upon a counter notice put in by the second respondent to the appeal against the refusal of an injunction by Mrs. Justice Wilkinson. And
just to be clear on your case, is your primary case that, in fact, your arguments on grounds 1 to 3 are so strong that actually those should have been determined in your client's favour so far as standing is concerned,
my lord, yes,
at the leave stage? So your primary case is not wait till trial, it's leave should have been granted outright.
Well,
is that right? I'm just trying to understand.
Our case is that leave was granted by Mrs. Justice Wilkinson. She doesn't set out the reasons why. We don't have a record of her reasons for granting it. But leave having been granted, the Court of Appeal ought not to have entertained the counter notice, the counter appeal on standing.
Right.
And should have left that matter.
If the Court of Appeal was entitled to look at the matter afresh,
yes.
Have I summarised your position correctly?
You have, my lord. Right. Although what I would say is this, that on the very basis of our ground for appeal, and following the logic of it, there is obviously still room for the trial judge, should this matter be remitted and this appeal be successful, for the trial judge hearing the claim, the substantive claim, to reconsider standing. We would say, on the basis of the evidence before your lordships, that it's clear beyond peradventure that the appellants have standing. But But ultimately, I suspect your lordships may not want to, and perhaps would prefer not to, tie the hands of the local court when it comes to the trial of the matter.
It depends how clear it is, doesn't it? And what the basis is for the decision. Whether it depends on particular facts that won't be established till the trial, or whether the answer is apparent on the facts that exist already.
Right, my lord, yes, and clearly a matter for your lordships. But we say that the case for standing is extremely strong in this instance. As I said, I won't address the academic points made by my learned friends in any more detail. There has been a question as to the status of the Attorney General in these proceedings, and to take the matter shortly.
The point about his standing, isn't
it? My lord, that's right. I don't want to labour the point, but he's only complaining about his standing now. And the Attorney General's played a part in these proceedings for, nigh on 5 years, without raising a question as to his standing. And not just a part in the proceedings. In fact, the government of Antigua and Barbuda, whom I understand the third respondent represents, is the developer. The application for planning permission submitted on the 12th of July of 2018 makes it clear that the government of Antigua and Barbuda is the developer. Perhaps we can just go to it, my lord. It may be that it's clear as plain as a pikestaff to your lordships, but I would perhaps just take you to it. Page, all the ones, 1111, 1111 is a letter from Mr. Bernard T. Lewis of the airport, the Antigua and Barbuda Airport Authority, to Mr. Southwell, the Chief Town and Country Planner. And it makes it clear that the ABAA are acting as an agent for the government of Antigua and Barbuda.
Well, that's the fourth paragraph.
My lord, yes. And that the government of Antigua and Barbuda have agreed to make a new application for permission to construct the new Barbuda runway. To this end, please find attached 3 application forms. I should say that the paragraph before that refers to the earlier application, which Mr. Lewis says was submitted in error. There we are.
I think you mentioned the 2017 application before. Do you have the page?
Yes, my lord. Let me find that for you. $1,049.
Thank you.
Perhaps we can just turn that up and you'll see the nature of that application. It bears a different application number, may be difficult to read, but it should be G19-2017, page 1049. This application only runs to 5 pages. It's made in the name of the applicant, BHM International. You'll see it's actually an application, although I don't think any of us have made this plain in our written cases, for approval in principle.
Yes.
Not for full planning permission or a full development permit, just to be accurate. You'll see that there's a date stamp, approval in principle. So what was sought was granted, 15th of May 2018.
Where do we see that?
On the right-hand side of the page, in the middle, a stamp with Town and Country.
Oh, yes, approval in principle.
Well, there's a tick opposite G as well, isn't there? Oh, that's what they're seeking, is it?
I'm sorry, my lord.
I was just looking at the tick opposite G. That shows what they're asking for, does it?
Yes.
Yes, it does. Yes, forgive me. And then turning over the page, you'll see what was being proposed. Paragraph 1, page 1050, construction of an airstrip or runway. And then 3, you might note, start date September 2017, completion date August 2018. That was what was proposed. So this was a retrospective application for approval in principle.
After they'd already started work?
After they've already started, and not for full approval, but approval in principle, which doesn't in fact enable you to construct anything, as you'll see from other documents that we've put before the court. And then just turning over the page to complete the exercise, page 1052. Forgive me, I'm working from paper, but so my reference to turning over the page is not particularly helpful. 1052, you'll see the words in the middle of the page, recommended for approval. That was a recommendation of the Department of Environment. And then the supporting documents are at 1053, 1054. And you may be able to decipher what these are, but they're effectively Google Earth shots of the island, or at least the part of the island where the runway sits. That was it. And
I wonder whether we should note at 1050 in the application type of interest that the applicant has in the land.
Yes,
it
my
says
lord.
The government of Antigua and Barbuda is the prospective owner or tenant.
Yes. And we have we don't take any issue with the ownership of the land, and so that's worth noting. My lord, I was making the point about approval in principle, not granting permission for construction to be carried out or a material change of use or anything of that nature, anything that could be described as development. And my lord, you'll see that Mr. Southwell, I think it was, makes that point plain in a letter sent to Mr. Stanley Smith of the Airport Authority, 15th of May 2018, on granting approval in principle at page 1106, second paragraph.
Is that the same date as the approval stamp on?
Yes, the approval stamp. I think there might be reference to it being the 18th of May in some of the pleadings, but it's the 15th of May, quite clearly from what we see on the stamp. While we're close to the original application, my lords, it may be worthwhile just looking at the letter of.
I'm so sorry. On this letter, you're showing us what did you want us to read?
Second paragraph, my lord, where it indicates what approval in principle entitles one to, and it doesn't entitle one to carry out any development, building, mining or engineering works.
It's very much the equivalent of outline planning permission in the UK.
Exactly, my lord. In fact, many of the provisions that we're concerned with are very similar to those that we're all familiar with in this jurisdiction. My lords, 1055, there is a letter from the Chief Environment Officer of the Department of Environment, Diane Black Lane. I'm trying to decipher her signature, but it's dated the 4th of December 2017. And it perhaps just completes a picture as to what was going on the site at the time when the application we've just looked at was made. This is a letter that came to the Appellants in, I think it was June or early July of 2018, following a Freedom of Information request of the Department of Environment. But it was written to Mr. Southwell, the Chief Town and Country Planner, and it makes plain that a site visit was conducted, first paragraph, at 10:55 on the 28th of November, at which time the DOE was able to observe that work on the project was well advanced and that many of the negative environmental impacts had already occurred in the absence of an environmental management or mitigation plan. It says this could have been avoided had the application been received and reviewed by the DOE prior to the commencement of work. Further, no plans or concept for the access road nor the terminal buildings and facilities have been presented. And then it goes on to say this, that although an environmental impact assessment dated 26th of June 2017, clearly we don't have that, accompanied the application, the document reflects significant gaps both in terms of its content and scope. Critical aspects of the archaeology, biodiversity and geology at the site were not recognised and captured in the EIA. Therefore, no mitigation measures were implemented to safeguard against unnecessary negative impacts on these features. Further, several key elements such as ground-penetrating radar analysis, hydrogeological study and prehistoric site assessments were not carried out during the conduct of the EIA. The EIA did not consider the construction of the new road, the terminal building and other ancillary facilities and services which would be required for a properly functioning airport. And then there was a reference to the opportunity to quantify prehistorically valuable sites being lost, critical biodiversity, habitats and ecosystems which might already have been lost. And the recommendation is that a thorough assessment be carried out to determine if any valuable features remain on or in the vicinity of the site, and whether any damage can be mitigated at this late stage. The author talks about, in the following paragraph, the development of terms of reference, which could inform additional work required to bring the EAA in line with national regulatory requirements. And then refers to the actual application that we just looked at. And this is where I got the Google Earth photographs comment that I made earlier from. In fact, she says, the supporting documents consisted of two, she emphasises that with two in brackets, annotated Google Earth photos. There were no site plans for the new road, the terminal building, or the ancillary features to support the airstrip. The DOE requested additional information from the developers, however, it was not provided prior to the issuance of this report. And then, to cap it all, during the site visit, the DOE discovered that approximately 10 to 12 acres of land was originally cleared at a site north of the current location for the airstrip. The DOE observed destroyed ruins that were identified as a plantation well by the Barbudan locals present, and recommended that an expert be asked to assess the importance of that site. Finally, in the paragraph at the end of the letter, the DOE recommended approval in principle, pending the submission of an updated EIA based on the terms of reference.
I mean, it does seem very strange that these are matters not addressed in the development plan. I mean,
yes.
Is there a development plan which has been published?
As far as I'm aware, no. What we have in the
has one been prepared but not been published?
We don't know, Milo. We're in the complete dark as far as that is concerned. What we do have in the bundle, I'll ask somebody to find it for me, is a decision of the government of Antigua and Barbuda on guidelines for a new airport on the island of Barbuda. And as I said, I'll find it.
I might have hoped that the government would abide by the legal requirements for planning.
Well, my lord, that I agree, and it's certainly a point I'll be making about the rule of law, because we see what is said by Lords Reid and Lord Hope in the Walton decision, about the need for everyone to abide by the rule of law, not least, one would have thought, the government of a particular principality or country, in order to show, by way of example, what others should do when deciding that they would wish to construct something, let alone a runway on an island such as Barbuda with such a fragile ecosystem.
And just on the structure of the planning law,
yes.
one looks at the Physical Planning Act.
Yes.
It talks about, first of all, drawing up a development plan,
yes.
and then individual applications for planning consents are assessed against the backdrop of that plan. But you're saying that no plan has been
well, there's no plan against
drawn up.
There's no plan that we have seen which
no published plan in any event.
Certainly that addresses the construction or the zoning, if I can put it that way, of an airport. Where this
I don't think the point is whether or not the airport is mentioned. I mean, if there is a plan which doesn't mention an airport at all, that of itself is significant.
Yeah.
Well,
these are questions that the board can address to the respondents.
Yes, my lord. But certainly the development plan is the starting point, as one would expect, and indeed
yes.
one
Yes,
sees in our jurisdiction for any determination. And while we're perhaps on...
Well, I was going a bit beyond that. I wasn't just saying, well, we do that in this country, therefore they should do it there.
No, but
it's part of the structure of the Physical Planning Act itself.
Yes, Section 25, which you'll find, my lords, at page 2094, makes it plain that in considering an application for a development permit, the authority shall give principal consideration to an approved development plan for the whole country, if any, and an approved development plan applicable to the land to which the application relates. It does say, if any.
Right. In fact, I was looking earlier on, so at page 2081, you have part 3, which is a whole set of provisions dealing with development plans. Now,
yes.
I appreciate that it doesn't seem to be mandatory. Well, I wonder. No, it's not mandatory that you have a development plan, but certainly it seems within the structure of the Act that it's expected
yes.
that one would start from the sort of top down, if you like, an overall strategic plan, which is the development plan, and then assessment of individual applications in the light of that strategic plan.
My lord, yes, and Section 25 makes it plain that that's the starting point for the authority when determining whether or not planning permission should be granted. So.
Yes, I mean, again, on the structure of the Act, page 2088, you
yes.
move from Part 3, which is development plan, to Part 4, which is control of development of land. So you've moved from the plan to grant of planning consents.
Yes.
And as you point out, Section 25, which is in that part,
exactly,
deals with the matters to be taken into account, including an approved development plan.
yes. I think the words, if any, in paragraphs 25(1)(a) and B provide for the possibility that there is no development plan.
Yes, they do. Hence our questions. We just didn't know whether there was one.
My lord, that's right. I mean, and I'm afraid nor do we. But what one sees at page 2095, 25, section 25(2), while we're on this page, so we don't perhaps have to go back to it, is that in addition, when determining whether or not to grant planning permission, the authority should take into account the following matters as appear to be relevant. And 25(2)(a) it sets down that those matters include any representations made by a person with regard to the application or the probable effect of the proposed development. And that was the focus of Mrs. Justice Wilkinson's determination when she came to consider my own friend, certainly for the airport authority's arguments on standing in response to the second application for an injunction.
Just on that, can you assist me with how one gets to the making of the representation? So doing the best that I could, but I would welcome assistance. I was looking at section 22, which starts on page 2090.
Yes.
which says where a minister has by order designated certain classes of development as likely to derogate, and then you get shall, by written notice, require the applicant to give details and publish details. Now, appreciate we're not dealing with that case. But then subsection 2 says, without restricting the generality of subsection 1, the notices referred to in A and B shall be served in respect of any application, and then F. For permission to carry out any development in connection with which an environmental impact assessment is required.
Which is where we are. Because
yeah, well, and I just wanted to track it through. Am I right in thinking that we're there because of what is said in Schedule 3, page 2165, that an EIA is mandatory if there's a proposal for an airport?
My Lord, yes, it shall be required, an airport, port or harbour,
right,
including a yacht marina.
So I've understood it correctly so far. And then if one looks at section 22.3, page 2091, it seemed to me there was a word missing there. So it says the town and country planner may, and in respect of an application referred to in subsection 2, I think shall or must, publish a notice.
Which page, section is it?
2091, bottom of the page.
Thank you. Oh, yes.
That's certainly the way I've read it, although I'm not sure I noticed that the word shall or must was not included, but I see that's certainly how I've understood that provision to apply.
So if that's the correct, I'm raising this so that Dr. Dorset can tell me if I'm wrong as well. But that says if you're dealing with an application within subsection 2, and we are because of subsection 2F, the planner must publish a notice and affix a copy of the notice on the land to which the application relates. And then one sees B, inviting comments and representations, whether in writing or orally on such application.
My Lord, yes.
And so that's, if I've understood that correctly, and I think you're saying...
I am saying you have.
That I have. That's an invitation to people generally to make representations about the development. And I think that then feeds in, again, I'm asking for your assistance to what you were showing us in section 25 2A on page 2095.
Well, my lords, it does, because one would expect, first of all, in an EIA, in the case of an EIA development, that the requirement in section 22.3 is complied with. The notice is published, it's affixed to the land. Invitation for the public are invited to give their comments and representations, and those representations, should they be provided, are then taken into account under section 25.2a.
Yes, thank you very much.
It has to be said that there is no evidence that the chief town and country planner
did any of these things,
and that rather stymied the appellants' ability to comply formally with the Physical Planning Act, and led to them taking other means and other steps in order to make their objections known. But what we do say is they can't possibly be criticised for not making representations in response to a notification that was never given.
Well, I'm seeking to clarify my mind about the structure of this. Can I ask you another question? In the original application for judicial review, reference was also made to the Barbuda Land Act 2007. Yes. We don't have that in the bundle, and you don't seem to base any argument
No, my Lord, and your Lordships, or at least certainly the Board, has given judgment in the case of Mackenzie Frank.
Yes.
On the Barbuda Land Act, or on a case concerning the Barbuda Land Act and its application. I'm pretty certain one or two of the board will remember it. Yes, but we don't place any weight on the submission made and indeed included, I think, in an affidavit sworn by Mr. Mussington about that act, or indeed any interest that it might bestow on Barbudans. Our case on standing is on much firmer ground, I would respectfully submit. And that is that they have personal standing because they will be affected by the development themselves. I'm not just talking about the noise of the 757s or whatever they might be flying in, because this is a runway that one will see can accommodate that sort of aircraft. But also there is the risk to groundwater from stormwater runoff contaminated by the activities on the site. And then obviously one has, and I'm really summarising their case on standing, but for your lordship's convenience at this stage, they also have a genuine interest in the wider environmental effects of the development on the flora and fauna of Barbuda. I'm talking in particular about the Barbuda warbler, the Barbuda fallow deer, the red-footed tortoise, the magnificent frigate birds. We're not talking about an osprey, no mention of that flying across Barbuda. Perhaps they do occasionally, but we're in exactly the same ballpark as that contemplated by Lord Hope in the Walton case. And that's the fauna. Hope I've not missed any out. But the flora includes the Antiguan and Barbudan national tree, the whitewood tree. And one only needs to see the work that's been undertaken, both at the abandoned site and then subsequently at the appeal site, if I can call it that, to imagine that has been affected by this development. So there's not just the fact that they have a genuine concern about the environmental impact, but also, as far as Mr. Mussington is concerned, I don't think I can say this about Ms. Frank, but he has sufficient knowledge with which to bring the claim before the Antiguan and Barbudan courts. The claim he has been trying to bring now since 2018.
And do you say that every citizen of Antigua and Barbuda has an interest in the government abiding by the law of the country?
Of course, my lord. Yes, and that is a universal interest. One would think, but clearly in the context of this case would apply to every citizen of Antigua and Barbuda. And indeed, every citizen of Antigua and Barbuda would be entitled to have an interest, a genuine interest in the protection of the environment. But we've seen what Lord Reid and Lord Hope said about their ability to bring a challenge by way of judicial review in the Walton case, and in such circumstances, and it does depend at least to some extent on them having the wherewithal, the sufficient capability, the sufficient knowledge to do so. What Lords Reid and Lord Hope don't suggest is that one needs to be an expert necessarily in the construction of a runway and the impact of a runway in order to bring a challenge by way of judicial review to the adequacy of an environmental impact assessment.
Now, we must let you develop your submissions on standing, but can I ask one question first? I think under the Environmental Protection Act that was in force at the relevant time, there was an obligation on the authority to have the EIA on their website.
That I am not aware of, and I will...
Could I refer you to page 1797, please?
Thank you, my lord.
This is section 77(1) of the 2015 Act, which is concerned with Environment Registry. The Department shall, in collaboration with such appropriate authorities, establish and operate a registry known as the Environment Registry for the purpose of administering the information on the environment. The Environment Registry shall contain all documents produced, collected or submitted to the department in respect of C, in environmental impact assessments. And I recall, I'm just trying to find the provision, that the documents were to be available on the website and open for inspection, I think for, certainly for physical inspection, I think for 2 weeks. But it's something you can come back to, but it does seem to suggest that there was a registry that should have contained EIAs.
My Lord, yes. I'd be surprised if they're on there, such a registry, because one would have thought that if they were, then the simple thing for the respondents to have done would have been to say, look at the registry. But it certainly seems as though the provision was there for, and the requirement was there for them to be posted on the registry. Can I come back to your lordships, perhaps having heard what my learned friends have to say about that?
Please do.
Just on that, section 78 does provide for regulations for inspection of the register and ability to obtain from the department a certified copy of a portion of the register, which would seem to include an EIA.
My Lord,
if that's correct.
That seems correct. We now have the 2019 Environmental Protection and Management Act.
I think that there is more specific provision. Is it section 43?
Section 43, thank you, my Lord. The Act begins at 1894, and yes, I see. Review of the EIA, registration, publication, and so forth. But
sorry,
this Act, of course, didn't apply at the time.
Yeah.
No. 1932, my Lord. Lord Sales.
Thank you.
Is where one finds section 43. That concerns a review of the EIA. And then subsection 2, the department shall post the EIA received under subsection 1 on its website and shall make the report available at its offices for public inspection. So it certainly suggests that there ought to be full disclosure of an EIA.
Yes, but I mean, while that may not have governed at the time, it does call into question the refusal of disclosure.
My Lord, yes. I mean, we would obviously say that there ought to have been disclosure as a consequence of the full duty of candour that the respondent...
Well, before you get to there, ought to be disclosure at the time of the application to give people a chance to comment on it.
My Lord, yes, we don't need to rely on the duty of candour for the reasons your lordship's given. It's a bit difficult to challenge an EIA when one doesn't get the opportunity to even see it.
Yes. Well, we better let you develop your submissions on standing because the clock is ticking.
Sure. Yes. Can I briefly just take your lordships to the development permit, which I think I was going to take you to initially. The permit granted on the 18th of July 2018. This was the second grant, but this time in full, page 1119. And I was saying, in fact, this is what led me off to the original application for permission in principle. The government of Antigua and Barbuda are in fact the developers, and one can see that from page 1119. This is the application made received on the 13th of July 2018. Name of applicant, Government of Antigua and Barbuda, and then there's a reference to the architects and contractors and so forth. Approved, date stamped 18th of July 2018. And just turning over the page, same exercise but very briefly done. Paragraph 1, 1120. What's proposed? Runway for code 4C aircraft. That's where I got my reference to B757s. And then state the proposed source of water and electricity. Water will, I think, be provided from aqua Yes, when the terminal, not a part of this application, is built. So there's clearly a terminal proposed. Standby sources will be a cistern. Electricity will be by Aqua. I can't read the rest, my lords. And then one can see that the grant, the application was approved. Page 1121. We know it was approved on the 18th of July of 2018. What we don't see, and these documents run now through to 1164 with lots of plans attached, but what we don't see anywhere in this documentation is a note of any conditions that might have been imposed on the grant of planning permission, or the grant of the development permit, I should say. And
is there anything that records the decision apart from a stamp?
My lords, yes, there is a formal notification, I think, at page 1118. A permit for a development at Barbuda for application number is hereby granted to the Government of Antigua and Barbuda on the 18th of July 2018. Now, Mr. Southwell, the Chief Town and Planning, Town and Country Planner, subsequently wrote to the...
I'm so sorry, just before we leave the application, was the application accompanied by an EIA?
If I can take your lordships back to that letter that I started with at page, all the ones, 1111, page 1111. Your lordships may remember the penultimate paragraph set out, please find attached 3 application forms, a hard copy of partial construction drawings which show the location plan, site plan, and other things. Also submitted is 1 hard copy of the revised EIA report with supplements, and an electronic copy of the same.
Yes, thank you.
And I think in addition there were the geology reports, which are now to be found at the back of the bundle. And I took your lordships to the additional evidence and the email from my instructing solicitor regarding their admission. Following the grant of planning of the development permit on the 18th of July, there was then a letter written by the Department of Environment that your lordships will see at page 1165, dated the 10th of August 2018, headed Review of Revised EIA for New Barbuda Airstrip. And as I understand it, that letter and the review is the review of the revised EIA that was submitted with the July application for development permit. It says much of what was said in that letter of the 4th of December 2017. But if one turns over to 1166, one can see that the DOE recommended, halfway down the page, that the project be provided with conditional approval.
It seems another example of make the decision first and go through the process afterwards.
Shutting the stable door after the horse has bolted, because this post-dates that stamp, 18th of July 2018, suggests there be the grant of conditional approval. And Mr. Southwell, the Town and Country Planner, the Chief Town and Country Planner, then writes, when he comes back from holiday on the 10th of September 2018, page 1188, to the Antigua and Barbuda Airport Authority to indicate that he's had this review report from the DOE and that the DOE had recommended that the project be granted conditional approval, and that the Development Control Authority agrees and accordingly grants conditional approval. So we've now got 3 grants. We've got the approval in principle, 15th of May 2018, the development permit on the 18th of July 2018, and a conditional approval dated the 10th of September 2018. How they're meant to work together and how it can be, well, let me put it this way. There is power, as your Lordships may have seen in the Physical Planning Act, for the authority to revoke or modify the grant of planning permission. I think it's section 33, from memory, of the Physical Planning Act. But there's no evidence to suggest that the grant of the development permit on the 18th of July 2018 has ever been revoked or modified. This grant of conditional approval, the 3rd grant, doesn't purport to modify it. It stands, as it were, extant, as does the grant of the development permit on the 18th of July, which appears from the documents we have to be unconditional. Certainly we have no evidence of any conditions attached. And so, stepping back, one might conclude, I would respectfully submit, fairly, particularly given the absence of evidence disclosed by the respondents, that this is shambolic. It's totally unsatisfactory. And there is no proper compliance with the Physical Planning Act.
Well, the work was steaming ahead all this time until there was an injunction granted to stop it.
Sorry, my lord, I missed
the work was steaming ahead all this time until an injunction was granted to stop it.
It was, my lord.
Before the decision was taken, and then before the process was gone through to decide whether the decision ought to have been taken.
My lord, yes, and you know, from what one sees in the papers that we have, it appears that the work is still going on. And whether or not
they challenged the decision to apply for judicial review on the grounds of procedural unfairness.
My lord, yes, the respondents were denied the ability to argue against the application for leave and by Mrs. Justice Wilkinson, having filed no response to the application. They appealed against that decision to the East Caribbean Court of Appeal, were successful in that appeal on grounds of unfairness, but did not raise the issue of standing at that appeal.
Can I ask what exactly the conditions were? Are these the ones that follow on in this letter from Department of Environment, 1188? Because I'm slightly confused as to exactly what the conditions were.
I'm afraid I don't think I can assist your lordship, because I am equally confused, and those instructing me, my clients, have been kept in the dark. There is perhaps one thing that I should add in terms of the points made by my Lord Hodge on the Environmental Protection and Management Act provisions. The appellant, Mr. Mussington, did make a request to have the EIA provided, and he was provided with the letter of the 4th of December 2017, but nobody pointed him to the registrar, the register, where he might perhaps have expected to find the EIA. So I think it's safe to assume, perhaps, an inference to draw that the EIAs do not sit on that register, or at least didn't at the time. Mr. Southwell deals with his decision-making in his affidavits, and I only want to give you a page reference to, if I can, my lord. I think I'm being told page 9, but I'll just check that, my lord. Yes, your lordships will find Mr. Southwell's affidavit at page 983 through to 988, 19th of September 2018.
Can you give me the page number again, please?
983, my lord.
983.
And I'll invite your lordships, perhaps not to read it now, but to certainly read through it before giving judgment in this case, and perhaps to note his explanation for the grant of approval in principle at a time when he declares, this is a sworn affidavit, at a time when he declares that the Development Control Authority had no knowledge of physical work being done on the site. You'll see that at paragraph 7. No knowledge of physical work being done on the project. Well, we know that's not right, because that letter that I showed you, dated the 4th of December 2017, that letter from Diane Black Lane, made it clear that there had been a site visit on the 28th of November 2017 where it was clear to the site officers, the officers that attended that site visit, that the work was well advanced. That was a letter that went to Mr. Southwell. Mr. Southwell addresses his communication with the first appellant, Mr. Mussington, paragraphs 9 through to 11. And though it makes no difference to the question of standing, he suggests that Mr. Mussington was verbally abusive and disrespectful to him. And Mr. Mussington denies that categorically, and you'll have seen that perhaps from a subsequent affidavit that he sworn. And then he goes on to say, Mr. Southwell, that I'm advised, paragraph 12, by counsel and very believed to be true, that the lands upon which the airport is being constructed are not lands falling within the jurisdiction of the Barbuda Council. Therefore, there was and is no obligation on the part of the DCA to consult the council. And your lordships may well have seen in section 24 of the Physical Planning Act, there is a requirement to consult the Barbuda Council for any development, particularly EIA development on the island. He then says, nevertheless, there were in fact consultations on the Barbuda, I'm not sure how this should read, but on the Barbuda, on the Paradise Found project, another development, and airport. There were 2 votes by the people of Barbuda who voted resoundingly in favour of the project and airport. The Barbuda Council and Cabinet also approved. If that's a reference to anything, we don't have any any documentation to back this up. Mr. Southwell didn't think to exhibit any such consultation documents or record of votes. But if that relates to anything, it appears to relate to some consultation outside of the Physical Planning Act, and certainly doesn't touch on the question of whether or not he complied with section 22(2)(f), I think it was, of the Physical Planning Act. And indeed, Mr. Southwell doesn't refer to the obligation he had to publish those notices anywhere in his evidence before this court. My lords, then can I perhaps take your lordships to the key points we make on ground 1 and the question of standing. As I said, Summarising our position, we say that the appellants are personally and directly affected. They're both Barbudans. They live on the small island in nearby Codrington, not a stone throw away, but perhaps less than a couple of miles away from the airport itself. They participated as best they could in the planning process. For your note, my lords, perhaps I can just give you the references to their participation. And most of this is in Mr. Mussington's affidavit, his first affidavit, which I think you'll find at certainly the key paragraphs, page 930, 931. The first appellant visited the site in November of 2017, made inquiries about whether or not there was a development permit, and then, as he describes it, was warned off by the police. He got a visit from the police saying that he shouldn't trespass on the land. That was on the 22nd of November 2017. He, with other Barbudans, then wrote to the Prime Minister expressing their concern. That was a letter 20th of February 2018. My lords, the letter is at 1099 to 1101. It's a letter with the schedule of, or petition perhaps one might call it, from about 20 of the Barbudans who were concerned about the development. On the 28th of February 2018, he called Mr. Southwell at the DCA, the first respondent. You'll see his reference to that telephone call at page 932, paragraph 15 and 17 of his affidavit. A further copy of the letter that had been originally sent on the 20th of February was sent to the Attorney General, the third respondent, copied to the Prime Minister by the MP for Barbuda, Mr. Trevor Walker. That's a letter which you'll see at page 1102. The appellant's legal representatives then sent a letter before action to the third respondent. That's at 1104 to 1105. Together with those same copies of the letters dated the 20th of February 2018 and the 5th of April 2018. No acknowledgement or reply ever received to those letters. On the 26th of June 2018, the first appellant wrote to the Chief Town and Country Planning Officer, Mr. Southwell, requesting information about the development. That's at 1108 to 1109. On the same date, he wrote to the Department of Environment to request a copy of the department's review of the EIA. That's 1110. On the 2 days later, 28th of June, the DOE responded and provided the appellant with a copy of that letter, the 4th of December 2017. On the same day, the 28th of June 2018, the first appellant spoke to Mr. Lewis at the DOE, and he confirmed to Mr. Mussington that no revised or updated EIA had been submitted. You can see reference to that at paragraph 24 of the appellant's first affidavit at page 934. And then on the 4th of July 2018, the first appellant wrote again to Mr. Southwell, page 3778 to 3779 at the end of the bundle.
Could you give the page reference again?
Yes, 3778 to 3779.
The date of the letter?
4th of July, my lord. Forgive me, 2018.
Okay.
So that was all in the context of him not being able to make submissions to any formal publication of the planning application. Indeed, it was made in the dark as to what was going on behind the scenes. There was no knowledge on the part of the appellants that planning permission had been granted, whether it be in principle or otherwise, until that information was disclosed in a kind of drip-fed way during the course of these proceedings. So they participated as best they could in the planning process. They'll be personally affected, but they also have a genuine interest on the fragile and precious environment of the island. And one can see that from what is said by Mr. Mussington in his first affidavit, again, page 9 in the same affidavit, page 939, my lords. If I can take your lordships to that. Paragraph, one can see how long this was, paragraph 2500, under the heading Urgency and Emergency Injunction. He says, I who live in Barbuda am directly affected by the construction of this new airport, and there is also a wider public interest in that the respondents and each of them breached the planning laws of Antigua and Barbuda in commencing the development and construction works of this airport, continuing with its construction. So really the point that my Lord Legate made about an interest in the rule of law. Over 300 acres of lands at the new airport construction site have been cleared for the construction of the airport. This area comprised forest lands in Barbuda that were used for grazing, farming and hunting by the Barbudans. I think that should read, and other Barbudans are no longer able to access, use and enjoy these lands as a direct result of the construction of the airport. The forest lands that have been cleared for the construction of the airport were the habitat of the rare red-footed tortoise and the feeding grounds of the Barbudan fallow deer. Rare ancient forest trees, including the white sap tree, I think that's the whitewood tree that I referred to, have also been cleared. I have a legitimate expectation that the airport development undertaken by and or on behalf of the third respondent by the second respondent and overseen by the first respondent complies with planning laws of Antigua and Barbuda. And then in a document that your Lordship will find at the back of the bundle, the application, forgive me, Lord, the application for leave for permission to apply for judicial review. It begins at page 3714. If I can ask your Lordships to turn up page 3728, you'll see the heading at the bottom of the page, whether the applicants are personally or directly affected and or public interest in the matter. And then five paragraphs I should say, the applicants set out their case in their application. They make the point that they have been directly affected by the construction of this new airport and that there is a wider public interest. And then, as one can see, this reflects the evidence given by Mr. Mussington in paragraph 2500 of his affidavit. And I draw attention to this, my Lord, because my learned friend for the second respondents, Mr. Marshall, has raised a point about compliance with CPR 56.3. And if I can just briefly take your Lordships to the CPR provisions, which your Lordships will find beginning, I'm afraid there are two versions in the bundle, I think, but certainly the provisions begin at 1712, and over the page at 1714 you'll see CPR 56.2, but then at 715 CPR 56.31, which reads, a person wishing to apply for judicial review must first obtain leave, and then an application for leave, subsection 2, may be made without notice. 3, the application must state name, address and description of the applicant and respondent. And then turning the page, H and I think are the points that Mr. Marshall focuses on. Whether the applicant is personally or directly affected by the decision about which complaint is made. Well, one can see from the application that I've just taken your Lordships to, not only do they say it, they head up those paragraphs with the very point that is required to be satisfied procedurally in CPR 53.1.3. So with respect to my learned friend, it's my submission that that point takes us nowhere. My Lords, I can hear Mr. Cottle suggesting I go to another document which I was going to take you to, so where he's reading my mind, and it is in the context of not just the genuine interest of the appellants in the environment and the protection of the environment, the fragile and precious environment of this island, but also to the question of whether or not, in accordance with the criteria laid down in the Walton case, either of them or both of them, but I'm going to suggest that this relates in particular to Mr. Mussington, has sufficient knowledge, sufficient wherewithal to mount a challenge of this nature. Your Lordships will find that not only does Mr. Mussington refer in his affidavit evidence to his experience and expertise, but he included as an exhibit his curriculum vitae. Rules advise they should be very short. This is commendably short. It's 2 pages long, but your Lordships will see it's at page 1011 to 1012. And it describes him under the heading Highlights of Qualifications as having over 30 years of experience in the field of marine biology, with particular knowledge of the ecology of coastal zone systems around Antigua and Barbuda. It says, consultant marine biologist working as part of teams carrying out environmental impact assessments of development activities taking place in the coastal zone in Antigua and Barbuda and other Caribbean islands. And then under the heading Relevant Experience and Accomplishments, you'll see that third paragraph, putting aside his community advocacy, he has over 30 years experience working as a consultant marine biologist on the EIAs, which he then identifies in bold. Projects, he said, include sand mining, disposal of dredge spoil, development in mangrove areas, hotel developments in the coastal zone, and then specific consultancies include. And just turning the page, my Lord, your Lord will see at 1012, he also explains that he was at one stage project director for the Barbuda Heritage Project and project manager for the Caribbean Regional Environment Programme, Barbuda Lagoon Project. And then he gives his education or history and his current then job, current I think now, but certainly then as a principal of the Sir McChesney George Secondary School on the island. Your Lordships will remember, I made the point that one doesn't have to have necessarily expertise in the development of runways and the impact of runways in order to qualify under the Walton criteria, if I can call it that. One simply needs to have sufficient knowledge, sufficient wherewithal. I'm obliged. Sufficient knowledge, sufficient wherewithal to satisfy that criteria. And in our respectful submission, Mr. Mussington's CV does just that. And one must remember, in the context of this case, we're not dealing with a country where necessarily one is replete with NGOs, non-governmental organisations, are able to bring such challenges, such as in the UK. And even a population currently of 2,000, maybe more with the developments that are proposed. But that's it, a small island in the East Caribbean. Mr. Mussington was perhaps, and I don't know, I don't want to speculate, but as well qualified as anyone to bring such a claim. Indeed, if it wasn't brought by him, then perhaps one might ask who could it have been brought by. If he's not entitled to have standing on the basis that he on the basis of his expertise and knowledge, then perhaps one might ask the rhetorical question, who does? And the problem is that if standing is taken as a high hurdle to jump in environmental matters, then they will not be properly addressed, and the rule of law that Lord Hope refers to in the Walton case will not be maintained. And we can see, so far as we're able to see, what has been going on behind closed doors in this opaque way in relation to this development. And that we respectfully submit is just the sort of failure to comply with the rule of law that someone like Mr. Mussington should be entitled to challenge before this court and indeed the local courts of the East Caribbean. In other words, I'm conscious that I haven't taken your lordships to the Walton case, but
the board is familiar with the Walton case.
I'm obliged.
I have to say to you, Mr. Willis, you are now eating into your reply time. You've been, according to the schedule I've got, you were speaking till 12.
My schedule is till 12:30, my lord, and my learned friends for the first and third appellants begin at 12:30 and then take up till 1 o'clock, and then from 2 to 2:30.
That is fine. If that's the agreed position, unfortunately, the copy of the timetable I've received had a 12 o'clock deadline. But you will appreciate that the principal interest of the board is in your ground of appeal 1,
exactly.
The general question of standing. The issues about what happened in this particular case are obviously of less significance to the point that is of general public importance.
My lord, that's understood. And if we go to the appellant's written case, we begin at paragraph 27, page 1642, with the civil procedure rules that we're concerned with, 56.2, which reads, an application for judicial review may be made by any person, group or body which has sufficient interest in the subject matter of the application. And then this includes a non-exhaustive list in subsection or subparagraph 2. I'm looking, my lords, at my written case 1642. The governing provision in CPR Rule 56.2 is that an application may be made by any person. I'm going to restrict what I say to any person. It should read who, but which has sufficient interest in the subject matter of the application. And my lords, we give you a flavour of how that provision has been interpreted in paragraphs 28 and 29 in the East Caribbean, and indeed, I think in the in other courts in the Caribbean. For example, in paragraph 30, you'll see a reference to the, forgive me, I'm not going to read out the citation, but the Young case, where the Jamaican courts and Mr. Justice Fraser considered identical provisions in the Jamaican civil procedure rules and held that whilst persons who are adversely affected are listed as one of the subsets of interested persons at Part 56.22, the governing criteria is found in Part 56.21, which states that these are persons with sufficient interest in the subject matter of the application. It's to be noted that Part 56.22, in seeking to define eligible persons, uses the phrase includes. To my mind, this means, this to my mind means the groups of persons eligible to bring a claim is not closed, but would extend to other eligible persons who qualify as interested persons. And so we say there's no requirement that a person be adversely affected, personally affected, is another way of putting that, in order to, or indeed for them to bring themselves within any of the other categories, those examples set down in 56.22, before they may be accorded standing. The overarching test, we say, is simply that the applicant for judicial review must have a sufficient interest. And that, we say, is the same test, exactly the same test as applies in this jurisdiction under Section 31(3) of the Senior Courts Act, 1981. And turning perhaps to what my learned friends say about CPR 5621, and perhaps dealing first with the first and third respondents' case. Under ground 1, which their submissions begin at 1676, paragraph 34, the respondents note that in paragraph 39, page 1678, sufficient interest is a mixed question of fact and law, a question of fact and degree, having regard to all the circumstances of the case. We respectfully agree with that. The point is taken from the IRC case, the Fleet Street Casuals case, as it's been called. And one then sees paragraphs 43 and 44 of my learned friend's Britain case, page 1679. What I read is as an acknowledgement that the interpretation of the phrase sufficient interest is governed by, just as in this jurisdiction, in England and Wales, by the criteria and approach laid down in the Walton case and followed, endorsed, adopted by the Lord Chief Justice, Lord Keegan, in the Duff case. And indeed, one sees at paragraph, 44 of my learned friends, the first and third respondents' written case, the criteria laid down at paragraph 20, taken from 29, paragraph 29 in the Duff case. And one can see that list, and I'm not going to read it all the way through it, but look at, if your lordships would, at subparagraph 6 and subparagraph 7. There's an acceptance here on the part of the respondents, first and third, that in the planning sphere, a litigant will ordinarily have had to participate in the planning process to have sufficient standing. We say that is applicable and indeed has been satisfied by the appellants I represent. Subsection 7, though, Roman numeral 7, there are exceptions to this rule, for instance, where the litigant was misinformed or misled about the planning process. Well, insofar as we haven't already made that point, we say that that is relevant to the question of whether or not the appellants could do anything more than they did in terms of participation, given the fact that so little disclosure was made of what was going on behind the scenes. And then ultimately, each case must be adjudged on its own facts, considering the context, the interest in play, and the purpose of judicial review to correct public law wrongs. This is all reminiscent of what is said by Lord Justice, my Lords Lord Reid and Lord Hope in the Walton case. And here we have the respondents accepting that it is applicable in the East Caribbean. But we know when one goes to the East Caribbean Court of Appeal's judgment, I'll take your lordships to it in a moment, that the Court of Appeal rejected the Walton approach, concluding that that case was not about judicial review. And so it's my respectful submission, and one can see this from the written case of the second respondent too, that the respondents are effectively accepting that the Court of Appeal got it wrong when they rejected the approach advanced by my learned friend taken from the Walton decision, and when they determined whether or not the appellants had standing. That in itself ought, in our respectful submission, to be reason enough to grant or allow this appeal, requiring the East Caribbean Court of Appeal or any judge in the court below to, insofar as they need to consider standing in the future, perhaps at the trial of the matter, when the factual and legal context is there for all to see, to determine whether or not the appellants have standing such that they should be entitled to the relief they seek. And in paragraph 45, my learned friends for the first and third respondents make it plain. They respectfully submit that Duff represents good law and is applicable and should be applied to Antigua and Barbuda. And we know that in Duff, the Lord Chief Justice Keegan made it plain that Walton case was the basis for those criteria set out in paragraph 29. One can see that from the decision in Duff.
Lady Chief Justice Keegan.
I'm sorry. I knew I was going to be a hostage, and I apologise to Lady Chief Justice Keegan unreservedly for not having done my homework. But the Duff decision and Lady Chief Justice Keegan's judgment are set out page 2474. This was a case concerning a challenge to the grant of planning permission for some infill development, nothing like an airport, or an airstrip, but infill development. And one can see that Lady Chief Justice Keegan distilled the following principles from Walton at paragraph 21, page 2480. Having said at paragraph 20, the test applicable to standing in Scotland is that of a person aggrieved. This is in different terms from the Northern Ireland legislative provision. However, in agreement with the judge, we think that the principles found in Walton are of more general application and assist in our determination of whether the appellant has sufficient interest within the rules. So there we have it. Walton is of more general application, made clear in the Duff case, principles distilled from it in paragraph 21.
And I think it's worth just noting paragraph 16 and 17, you get the applicable rule in Northern Ireland, which is the sufficient interest rule.
My Lord, yes, thank you. And then one can see that in paragraph 26, there's reference to a case that predated the Walton decision, the case of Ashton against the Secretary of State for Communities and Local Government. The criteria set out, that's taken from that case, set out by Lady Chief Justice Keegan over the page at 2483. And one can see, just as an aside, subparagraph 2, normally participation in the planning process which led to the decision sought to be challenged is required. What is sufficient participation will depend on the opportunities available and the steps taken. So reinforcing, we would respectfully submit our case on public participation insofar as we need to. And then paragraph 29, those points made by my learned friends in their paragraph 44 of their written case are accurately and set out. And so if Duff represents good law, so too must the Walton decision from which Duff is taken. And that in itself, one might think, is a good enough reason to allow this appeal, because you're just thinking about the academic argument that my learned friends advance. Can it be right that a decision taken by the East Caribbean Court of Appeal, which disregards the approach which my learned friends say should be applicable on the issue of standing and the interpretation of the word sufficient interest, can it be right that a decision of the East Caribbean Court of Appeal, which otherwise might be used by any number of parties and indeed judges as a precedent. Can it be right that that decision is allowed to stand in such circumstances? I'd respectfully suggest not. My learned friends for the first and third respondents then say, well, in the instance case, the appellant's participation in the planning process has been tangential at best. Now, what one doesn't see in paragraph 46...
What planning process one's encouraged to ask?
Exactly, my lords. But we do not see... We see one reference, and this is perhaps important because it undermines, I respectfully submit, the rest of the first and third respondents' case. One reference to the letter dated the 26th of June 2018, which they say was some 6 weeks after the developer had received approval in principle. Well, that was unbeknown to anybody. That's the only letter, and they describe it as tangential at best based upon that one letter. And then say over the page, in the circumstances, it's respectfully submitted that the appellants, in accordance with the Duff test, lack standing.
Where are you reading from?
Page 1680, paragraph 47. So the tangential at best reference, without any reference to any other of the long list of processes by which the appellants participated, is at paragraph 46. And then on the basis of that one letter, which appears to be all that the first and third respondents think amounted to participation.
Can you give us the bundle reference to that letter?
Forgive me, my lord. Yes, I can do that. I think I did in that long list I read out.
Probably did, yeah. So.
Let me see if I can find it again. 1108, my lord. Thank you. Thank you very much. On the basis of that one...
I'm very sorry, I missed that reference.
1108.
1108, thank you.
But it's on the basis of that one letter and the tangential description of it that my learned friends say that the appellants, in accordance with the Duff test, lack standing.
I mean, that just misses out the course of correspondence starting on the 20th of February, I think. My lord, yes, and the earlier attempts to find out what was going on, but the correspondence in particular. And then my learned friends appear to move on to a different point in paragraph 48, and with reference to the Good Law Project against the Prime Minister case. And the question of whether or not the appellants have more than just a strong and sincere interest, which is not doubted in paragraph 49. A strong and sincere interest in environmental matters. Although when it comes to paragraph 53, my learned friends submit that the appellants have not demonstrated by evidence that they have or have any genuine interest in the aspects of the environment they seek to protect. Well, that doesn't seem to sit very well with paragraph 49. They do go on to say or sufficient knowledge of the technical and environmental issues which may be caused by the construction of the runway. And I've taken your lordships to what I suggest is the evidence which meets that charge. So if one looks then at paragraph 54, the first and third respondents submit that since the appellants have failed to plead or show by evidence, they say, that they have sufficient interest or that their interests or rights were adversely affected, they don't have... Well, the case of Walton against Scottish ministers does not apply. Not sure that...
Well, they go on to seek to distinguish Walton on the basis that Mr. Walton had demonstrated a real concern about what he contended was an illegality in the grant of the consent,
my lord,
which was bound to have a significant impact on the environment. There is no similar evidence in this matter, they say.
My lord, exactly. And he wasn't a busybody, but Mr. Mussington and Miss Frank can be described not pejoratively, but on the basis of the case law as such, as a meddler or meddlers or busybodies. And part of the reason for that, according to the response, is that Mr. Walton resided in the vicinity of the western leg of the WPR. He was an active member of the organisations, demonstrated a real concern. Well, if the evidence that we put before you doesn't include that in Mr. Mussington's case, then I'm afraid I've perhaps rather underestimated the value of it. What
I think you said that Mr. Mussington lived, was it a couple of miles from the runway?
Codrington, my lord, which is the village to the east of the airport runway, and it's as the crow flies, I think it's no more than a couple of miles away. And perhaps while we're on that point, my lord, one can see from the evidence that was put in, and I appreciate, my lord, that perhaps the evidential material is not of quite so much import as the principle, but one can see from page 3561 of the evidence that was put in September of this year. That evidence included another review of revised EIA by the Department of Environment, and you'll see the letter at page 3552 to 3553. Again, somewhat of analogous to closing the stable door after the horse has bolted, but no matter. We have this now, and we've put it in before your lordships to consider. If you turn over the page, there's a formal 3554. There's a tabular page. Report submitted June 2018. I don't know if your lordships are following me on that. So it's all about the June 2018 application. EIA request, yes, submitted documents have been wholly unsatisfactory, and there's a reference to the EIAs and supplemental EIAs. Environmental risk concerns, breach of process. And this might be of interest to your lordships. Construction commenced prior to application. No Barbuda Council endorsement accompanying the application. This is from the Department of Environment, not from the appellant. EIA presented with significant gaps. Revised EIA persists with significant gaps. No monitoring reports, loss of archaeological and prehistoric hydrological access to road strip. And then, in the meat of the review...
I mean, the access road to airstrip point is that they have approved the existence of a runway without having addressed the environmental consequences of getting to and from it.
My lord, that's right, but the letter that I took you to, 4th of October 2018, yes, clearly indicates that there has been a receipt of an EIA for the road. It's known as the supplemental EIA, and that the DOE, page 3553, recommended to the the Development Control Authority, that approval in principle, again, be issued for the construction of the access road. Does your lordship see that at the top of the page? Approval in principle.
Yeah, oh, I see. Yeah.
But the review goes into some depth, although we don't have the EIAs themselves and the supplemental EIA, it goes into some depth over the pages that follow on from that letter and that one page of the report I showed you. And my lords, of concern perhaps to everybody in the room, but certainly to the appellants who I represent, is the point made at page 3561, bottom of the page, under the heading, this is a table identifying areas of concern, issues, update on actions to achieve compliance. Hydrogeology is the heading of this page. And if you look at the very bottom of the right-hand column, one can see these words. The ABAA also advised that one of the sinkholes identified in the hydrological study was full of water. In fact, that sinkhole, which possibly could have been one of the pre-existing wells on the site, is providing all of the water for the project operations, as well as most of the water being consumed by the village of Codrington. I'm not sure whether that's potable water or water being used for other purposes, but as well as most of the water being consumed by the village of Codrington. One doesn't have to be a marine biologist or an expert in EIA to understand the impact of that. My Lords, the appellant's case on ground one is simply this, that quite apart from participation in the proceedings, which ought in any event, putting aside the environmental concerns, to have entitled the appellants to standing, the East Caribbean Court of Appeal failed to apply the relevant tests and criteria laid out in the Walton case, which now, my learned friends, I've taken your lordships to the first and third respondents' submissions, but the same can be said for my learned friend for the second respondents, except ought to be applied in the East Caribbean. When one turns to the East Caribbean Court of Appeal's judgment, it begins at page 612. One can see that the Court of Appeal dealt with the appellant standing at paragraph 9 onwards, page 617. Onwards. And the key paragraph, perhaps, for your lordships is at page 623, paragraph 20. Having listened to my learned friend's submissions for the appellants, the Court of Appeal concluded, subparagraph A, the Walton case is not a judicial review case. And if you look at the bottom of that subparagraph, the case has nothing to do with the requirement for an applicant to have a sufficient interest to apply for judicial review under the UK equivalent of Part 56.2. And then subsequently, second subparagraph, the case did not alter the accepted common law position that a busybody or a person who is applying simply as a citizen cannot question the decisions of a public body using the judicial review process. Well, my lords, in my respectful submission, it certainly does. The Walton case makes it quite plain that a person who is simply a citizen, providing they have a genuine interest in the environment that they seek to protect, and that they have sufficient wherewithal or knowledge with which to bring such a claim, are entitled to standing in environmental planning cases. And one can see from the East Caribbean Court of Appeal's decision that it, in my respectful submission, went wrong in that particular paragraph, and as a consequence failed to apply the correct test and reached a conclusion that it ought not to have reached. Now, my lords, your lordships will appreciate I'm now out of time. I've not addressed grounds 2, 3 and 4, but they are, in my respectful submission, sufficiently addressed in the written case.
They're set out clearly in your written case, and the principal concern of the board is the one with which you have been.
I'm very for my lord. What we would invite your lordships to conclude is that the appellants are not busybodies, they're not meddlers, they're personally affected. They have a genuine concern for the effect of the development on the fragile ecosystem of this beautiful island of Barbuda that we're concerned with. And we invite you to allow the appeal on that basis.
Thank you.
Thank you.
Mr. Dorset.
If it may please you, I appear on behalf of the first and third respondents. The board seems to be mostly interested in ground 1 of the appeal, and I will address it. I have done so, beginning at paragraphs 34 of my submission, which is to be found at page 1676 of the bundle. My lords, I would want to make the point that the appellants, in presenting their case, in the court below relied on 56.22A of the CPR. That was how they grounded their sufficient interest argument. It is clear, certainly from the judgment of the Court of Appeal, paragraph 9 of the Court of Appeal's judgment that is under appeal, and also we notice from the presentation, the submissions, the oral submissions that were made by counsel representing the appellants. We reference that at paragraph 37 of our judgment, which can be found in the record at page 682. So what we say, the sufficient interest point is really a fairly narrow point, as it's a point that the appellants were anchoring their case on 56.22A. And what we say, they cannot now seek to now expand upon that. What we say is that having an interest in the matter is not sufficient. What is required is having a sufficient interest in the matter. And we say that when one looks at the position of the appellants, again, I would not wish to put words in the mouth of counsel, but there seems to be, if not a concession, at least an understanding that the second appellant, being a retired teacher, really doesn't have any much interest and expertise in this area.
He may not have expertise, but he surely has interest in living on a small island which doesn't have its fauna and flora disrupted by major construction carried out.
Well, my lord.
Carried out unlawfully.
My lord, we are prepared to submit that the second appellant, and certainly both of the appellants, might have a very serious interest and concern about that. But we say, just because one has a sincere interest in a matter, and we make this point, my lord, at paragraph 49 of our case, having a strong and sincere interest in environmental issues does not put you over the threshold.
That may not by itself, but if you're a local resident and you live in the area affected, that seems a pretty strong interest. We all have an interest in the natural world around where we live.
Yeah, well, my lord, if the ambit were to be carried that large, all of us have an interest in the world that we live in. That means the floodgates would open, and
nobody's asking for it to be carried that wide. We're talking about the population of a small island.
Yes, my lord. I accept that the population of Barbuda is small.
And equally important, the island is small.
Well,
and Mr. Mussington, for example, lives within a couple miles of what will be a busy airport.
Well, that's so, but I mean, in the nature of the Caribbean, most of the islands are small, and most of these islands are, in fact, almost all.
Well, if someone living 2 miles away from the major development doesn't have a sufficient interest in contesting it, who does?
Well, my lord.
Your case seems to be that nobody has a right to challenge the government's unlawful activity.
No, I would not put my case that way. I would not put this.
Well, nobody else has come forward. There's no organisation apparently available to do it, so it has to be a local resident.
Well, they certainly have come forward, but what we say, certainly in the case of Mr. Mussington, that what he has put forward as his expertise is that of being a marine biologist. And what we say, this is the development of an airport. It's not a seaport. It's an airport. It's a land-based development. And him being a marine biologist in and of itself is insufficient to meet the evidential requirement to act in the public interest. And that is an argument, my lord, that we make at paragraph 53 of our submissions. So we would not seek to cast doubt that on facts that Barbuda is a small place. They live perhaps a couple of miles from the new airport, but there has to be more. There has to be more if they are going to.
Can you identify anybody who would be entitled to challenge this development on your case?
Well, somebody who can speak to what airport would mean in terms of adverse environmental impact.
Now, is that realistic? Are there going to be people on the island of Barbuda with expertise in airport development?
Well,
I mean, I think you'd have to look pretty widely in these islands to find many with that expertise.
Well, if there are none, I mean, the government or the public bodies themselves are not putting up themselves so that every decision that they make is to be challenged. But if a proper challenge is to be made, it must be made on the ground established by CPR 56.2, and in this case, 56.2 subsection A. So
do you challenge the jurisprudence from other Caribbean islands which suggest that similarly worded provisions should be interpreted liberally?
No, we cannot make that. We cannot make that point, and we do not make that argument. We are cognizant that it must be afforded a fairly liberal interpretation, but liberal doesn't mean free for all. As I think one of the cases that we have referenced in our case is that to do so would run a course and carriage through the requirement for sufficient interest. So that is what we say. And when one looks, for example, we have referenced the case of the Friend case at paragraph 50 of our submission. This was a case dealing with the enforcement of plan and control. Lord Justice Richards, perhaps he has moved up higher, but he makes the point that having a very sincere concern about the enforcement of plan and control, that is not sufficient to make standing automatic. And we would say, with respect, that the appellants fall within that kind of categorization. As I said, we would not want to say that the appellants don't have concerns, sincere concerns, but that is not sufficient. My Lord, I would want to address you, or at least refer you, if I may, to paragraph 32. Paragraph 32 of the appellant's case. Paragraph 32 of the appellant's case, where they make reference to the Demas case out of Trinidad, and where at paragraph 30 they make reference to 12 points that were referenced by Justice of Appeal Jamador. And at page 1645, of the bundle, the first statement made there, standing goes to jurisdiction and is to be determined in the legal and factual context of each case. And the point that we would wish to highlight, it is a matter of judicial discretion.
Do you accept these points as a fair statement of relevant considerations, or do you dispute them?
No, I'm not seeking to dispute them. In fact, I'm latching on to point one.
Yeah, I know, so I'm just checking generally whether it's...
No, I have...
Yeah.
Yes, and what we say, it being a matter of judicial discretion, the question has to be asked, did the Court of Appeal, as a matter of judicial discretion, get it so wrong, blatantly wrong, that it merits the intervention of this court, of this board?
But I mean, it's a matter of discretion to be exercised in accordance with principles which have laid.
Yes, and principles, for example, as we find in the Friend case, and others.
But if the Court of Appeal misdirected themselves on the appropriate legal test, as it submitted they did, if that is correct, then they exercised their discretion on a wrong basis, so far as they were exercising a discretion. If so, then presumably we would have to re-exercise it if we reach that point.
Well, if you first accept the appellant's argument.
Yes, well, I'm sure you'll be addressing that, but that's their contention.
Yes.
That they misinterpreted, misunderstood Walton.
Yes. Well, what we say, we do not certainly want to cast any doubt in Walton. What we say, what has come from Walton has been a number of other cases, and as my learned friend has fairly represented, we place a lot of stock, in particular with the Duff case, which we say follows that stream of jurisprudence. And what we say is that looking at the principles that have been stated in Duff, those principles ought to be applied. Our point of difference with the appellants, we say that these principles are consistent with our position, properly applied. The appellants say otherwise. And, my Lord, we would say, looking at paragraph 29 of the Duff case, the judgment of Lady Justice or Lady Chief Justice Keegan, we highlight the last 3 points, point 6, 7, and 8. Beginning at point 6, in the planning sphere, a litigant will ordinarily have had to participate in the planning process to have sufficient standing. The party that is responsible for granting planning permission is the DCA. The only involvement and one can see from the chronology, there's no dispute about the chronology, the only involvement prior to the filing of the judicial review proceedings was a letter that had been written to the DCA, which was a freedom of information letter.
Well, was there public consultation in the planning process? Was there an opportunity given to residents to comment on the planning application? Were they provided publicly with the environmental impact assessment?
My Lord, that wasn't, there was no public consultation.
There was no consultation?
At least not as far as I'm aware.
So are you really suggesting that because the appellants didn't participate in the process, the reason being that there wasn't one, no opportunity afforded to them, that cuts them out then from even challenging it on the basis of judicial review? Is that a submission you're making to the board?
My Lord, we are not saying that that when one looks at these principles even, that one be too strict. These are principles that must be applied in context, having regard to the factual circumstances. But what we say, it is correct that there was no public consultation. I don't think I can say otherwise.
Well, then you can't seriously say, can you, that because they didn't participate in a non-existent consultation, that's a reason why they don't have standing to bring a challenge at all?
Well, my lord, I'm not saying that they did not participate in the consultation. It's the planning process.
What process did they have a chance to participate in?
I mean, are you saying that the provisions of the relevant Planning Act were complied with in this stage, in this case?
It's difficult to say, my lord. I think it is proper to say that there are certain deficiencies that this case brings to light.
And what are those deficiencies?
Among those deficiencies, there apparently is not a proper up and running registry.
There's not a
proper up and running registry.
No registry.
You mean the environment registry?
Yes, yes.
We looked at.
So that notwithstanding the provisions of the 2015 Act, the EIAs were never available to the public.
Well, it could be available to the public, but certainly not via the scheme contemplated with the establishment of a registry.
Well, your clients have even refused to make them available in the course of this litigation, haven't they?
My lord, the litigation has just hardly gotten off the ground.
Well, it's only been running for a few years now.
Yes, but what I say, the passage of time is only one aspect. We have not reached the stage because the Court of Appeal ruled that the appellants had no standing. We have not even come to proper case management for the putting in of a defense.
Yes, well, could we focus, before we go into the steps in the litigation, can we focus on the wider picture? Is there a development plan which highlights or which suggests that an airport should be constructed where this airfield has been constructed?
I talk about a development plan as pursuant to Section 9 of the Act?
Is there a statutory development plan which recognises or zones this area for an airport?
With respect, I don't have specific instructions, but I suspect that there is none.
You suspect?
I suspect that there is none.
There is not.
But I can obtain...
If you could inform the board after the event...
Yes, but I have a irking feeling.
Yes, well, in that circumstance where the public are not aware that that there has been approval of the zoning of an area for an airport, what steps were taken under the Planning Act to give notice of the application?
I'm not aware that any active steps were taken.
And do you accept that there was in fact a legal requirement under Section 22 to give notice? Sorry, 22, yes, to give notice.
Just.
Remind me the page of Section 22?
Page 2091. It starts on 2090, but goes over to 2091. It's page 2091.
2090.
Oh, yes.
So you'll remember this was the exchange I had with Mr. Willis.
Yes.
Seeking to confirm my own
2091. Yes. Thank you, Madam, for bringing my attention to it. There was a suggestion, and perhaps that there was a word missing from Section 22, subsection 3.
Yes.
Of that.
If I may say so, I think the first point was whether you accept that Section 22(2) applies on the basis of subparagraph F, that this was a development in connection with which an environmental impact assessment is required.
A development impact assessment is required for the development of an airport. Whether it
Right.
It doesn't matter where the airport is.
No.
A development impact assessment, sorry, an environmental impact assessment report is required. No bones about it.
Yes, thank you. And then you're going to assist us with section 22.3.
What we say, respectfully, that there is no missing word in subsection 3. The subsection reads, the town and country planner may, and then there are words before or after the comma.
So what's the relevance of the words in respect of an application referred to in subsection 2?
Yes, we said the town or planner may, and in respect of application referred to in subsection 2, publish a notice and affix a copy of the said notice to the land to which application relies. And so we say...
it's optional in every case, is it? Is that your submission?
Was that?
You say it's optional in every single case, including those falling within subsection 2.
Well, yes, it says may.
And there's no word missing?
No, because the word, the town and country planner may, and in respect of an application referred to in subsection 2, he may publish a notice.
Why is the word "and" there then, if you're right?
My lord, with respect, it doesn't do violence to the section. It just say, it just draws attention to applications reference or to matters referenced in subsection 2, but it doesn't defeat the whole intent of the section in terms of what the town and country planner may do. He may publish a notice. There is no strict requirement that he must or that he shall publish notice.
And are you saying that the government in this case, wishing to build an airport, have a position where the town and country planner has exercised a discretion not to tell anyone about it? Is that what's happened?
It appears so. Perhaps it's not the pretty state of affairs, but that there was no open consultation or announcement with respect to the...
and if it was discretionary, do you say that that exercise was lawful or not?
Well, it's certainly not illegal, it being permitted by that subsection.
Dr. Dorset, if one looks at the developments listed in subparagraph 2, they're all developments which potentially have very serious impacts on the population or the environment of Barbuda. Isn't the more natural construction of subsection 3, having regard to its wording and having regard to the nature of the developments listed in subsection 2, that there is a word missing, the word must or shall, after the phrase between the commas, indicating that for these particularly serious classes of development, there is in fact an obligation to consult or allow for consultation with the public of Bermuda?
My lord, we say this, that we are stuck with the text of the Act here, and perhaps any revision of it is a matter for Parliament.
But I mean, it's for the board to construe, to give a proper construction to subsection 3.
And we say a proper construction is to take the words and the language as is, and to avoid the temptation of inserting an additional word. That's
right.
But it rise to an astonishing result that without having the land zoned in a development plan and without any other publicity, the town and country planner is given a discretion to tell nobody. How could that possibly be consistent with a proper intention?
My lord, I accept that perhaps given the sensitive nature of matters that are raised in subsection 2, just on the face of it, things are dealing with toxic and hazardous waste and other matters. Perhaps it would have been wiser to have a more open door policy on the matter. But I cannot think that he can be faulted if he had followed the strict letter of the legislation.
Your interpretation have I understood correctly, that it's only for these serious things that there's even a discretion to consult the public? And that there isn't, if it doesn't fall within subsection 2, actually there isn't even a discretion to consult the public. He's obliged to keep it secret.
No, my
Is
lord,
that really what you're saying?
I would not want to put it that high. I'm not trying to advocate for secrecy in these matters at all.
Right.
But
I thought you were saying we should...
interpretation, it requires us to delete the words "and in respect of an application referred to in subsection 2.
No, ma'am.
Because they're doing absolutely nothing. Well, you're saying the town and country planner may publish a notice.
In any case.
In every case. That's what. So you're requiring us to delete the words in the commas.
No, my lord, I would not ask for any alteration in the text I would not argue for.
But it plainly can't be read as it is because it doesn't make sense. It's plain on its face that it's nonsense. So you either insert a word afterwards or you delete "and in respect of an application referred to in subsection 2. It's one or the other.
Or the third alternative, which I think you're disclaiming, is you just delete the word and you limit it to only. You can only do it at all in the subsection 2 cases.
That's what I was beginning to understand. But that would be nonsense, wouldn't it? Not to have any discretion at all in relation to other planning applications to consult the public.
Just one. My lord, in looking at the subsection 3, which the board seems to have some difficulty with the way it's written, perhaps a reference could be had to the very start of that section, which is section 22(1), which provides that where the minister has by order designated certain classes of development as likely to derogate from the amenities of the public or of adjacent or nearby properties, an application is made for permission to carry out development fitting within a designated area. The town and country planner shall by...
within a designated class, the word is important. Section 22(1) is looking at class designations by the planner. Section 22(2) is looking at individual applications.
Yes, but the short point that I would make, it is not a situation where the legislation is written so that there is no opportunity or no obligation to give notice by the town and country planner. The self-contained within Section 22, there is that obligation by use of the word shall to give written notice to the applicant with respect to certain matters. So
but only where an order has been made designating certain classes of development as requiring that.
Yes.
You're not suggesting, well, maybe you are, that any such order has been made.
No, I'm not suggesting
this case.
The only point I'm making is that the section 22, in certain parts, certainly in part subsection 1, puts an obligation on the town and country planner to give notice on certain matters.
Yeah.
But the obligation to give notice does not extend to all matters.
No, but the town and country planner under subsection 1 gives written notice to the applicant, requiring the applicant to do certain things. That does not apply under subsection 2 as such.
Yeah, my lord, I accept that. It is.
So we come back to subsection 3, and I don't know if there are any other provisions relating to publicity of an application in the Act, subsection 3. And if you're right that there is no mistake here, and the words "and in respect of an application" referred to in subsection 2 are OTOs, no, you say they're not OTOs. You say that there is the obligation in relation to subsection 2. The question arises, where is there any obligation to consider even the exercise of a discretion in relation to other applications?
My lord, I would not want to belabor the point at this point. What I would say is that perhaps what the town and country planner did by failing to provide notice of the application to develop the airport may have been unwise, but not unlawful.
Yes. Would that be a convenient place to adjourn?
Yes, please.
Thank you very much. The board will now adjourn.